First item on today's agenda is the approval of the minutes of June, the open session of June 4th, 2024. Do I have a motion?
Second.
Motion by Commissioner Centarini, second by Commissioner Susi. Any discussion? Hearing none. Roll call vote, please. Commissioner Susi.
Aye.
Sorry. Commissioner Centarini.
Aye.
Commissioner Peterson.
Aye.
Commissioner Ritchie is absent. Commissioner Strauss.
Aye.
The chair votes aye.
Mr. Revenue.
I'm sorry. His name isn't on the list.
Aye.
Sure. I was here. Not on the other one. Good. The next item on the agenda is the director's report.
Good morning. A lot to talk about today. I'll just note that we are live streaming for anyone who's watching. The link to the live stream, of course, is on our agenda. The meeting materials are on our website if anyone wants to view or download them from there. The live stream will cover the entire open session, and then as the commission goes into executive session, we'll close this meeting. It will stay closed until the commission reconvenes in open session when the meeting will come back in, however long that takes. One of the first things that the commission will do is report out any votes that were taken in executive session. And then a written report of votes taken in executive session is also posted on our website within an hour of the meeting closing today. So going through the report regarding complaints and investigations, we have 8 total complaints pending right now, including the 2 on our agenda today for initial determination. Advisory opinions, we have 8 pending advisory opinions right now, and we have 3 on today's agenda. Regarding APRA requests, we had 11 since the last meeting. We fulfilled all of those within 1 business day, as we always strive to do, rather than the full 10 business days. Of those APRA requests, 5 related to complaint matters, 3 related to advisory opinions, 2 related to financial statements, and 1 related to recusal statement. Just briefly mentioning financial disclosure, today's a significant day for financial disclosure because it is the deadline for people who sought and received a 60-day extension to file their financial disclosure statements. So we'll see, and we have already seen several statements filed today by high-level public officials who had sought those 60-day extensions. As of at least yesterday, I haven't added today's numbers in, but we've got about 4,060 financial disclosure statements that have been filed. We're a little over 97% compliance, still a bit ahead of this time last year. We have about 120 non-filers right now, which is a really manageable number. And we're still working to get that down before we start talking about conceivably starting enforcement actions against the last few people who haven't been filed. So then just finally, I just want to mention under General Office Administration, I'd like to introduce a new person we have at the Ethics Commission today. Each summer, we get an intern who's actually part of a fellowship from University of Rhode Island. Today with us, and for this summer, we have Jay Dos Santos. So Jay, you want to stand up for a second? That's Jay. She'll be with us this summer. She's our summer research fellow, and it's a paid fellowship that's sponsored by the John Hazenwhite Center for Ethics and Public Service at URI. Jay is at URI. She's double majoring in political science and gender and women's studies, and she's going to be helping us this summer with a lot of interesting projects, some having to do with our new recusal module that we just finalized, helping to get that up and running. And then she'll also be working on some advisory committee digests that we publish in our annual report, among other things. So, welcome, Jay. That's all I have.
Will any members of the commission have any questions from Mr. Bradley? Seeing none, the next item on the agenda are advisory opinions. The first signer is Phil Hervey with Council Amy Goins.
And before we get started, I'd just like to, as a reminder, we now have 8 commissioners. So 5 affirmative votes are necessary to adopt an advisory opinion.
Although there are only 7 here.
Well, we're not 8 in 1 second. There we go.
We'll let Commissioner Ritchie get seated.
Morning.
Good morning. Good morning.
Ritchie, and let you know that we're just starting the advisory opinions. And the first one is Mr. Hervey.
Good morning, Commissioners. This advisory opinion is in the tab A in your binders. Mr. Harvey is present today and attorney in the office.
Good morning, Assistant Solicitor for the Town of Barrington.
Mr. Harvey is the Barrington Town Manager. He represents that in 2021, the town purchased certain property in town, and several years after that, the town council approved a redevelopment plan that includes the development of 6 single-family sites, a public park, and a pocket neighborhood with 12 cottage-style single-family homes. In January of 2024, the town issued a request for proposals for the development of the pocket neighborhood. Mr. Harvey represents that there was only one developer who submitted a proposal. He reviewed that proposal and noted that the proposal included the intention of the developer to engage the services of RE/MAX River's Edge for the marketing and sale of the real estate units within the pocket neighborhood. Mr. Harvey explains that his spouse is employed by that real estate company as an office manager. He spoke to the solicitor, and based on their discussions, he decided to recuse from any decision-making on the whole project. In March of 2024, the developer, FJS, removed RE/MAX from their proposal. Additionally, Mr. Harvey represents that as an office manager, his spouse received a set salary. And her salary or any bonus that she may receive does not depend on any particular sale by the real estate company. Based on these facts, Mr. Harvey seeks guidance whether he may now resume his duties relative to the project. And that would include the oversight of the performance of the towns and the developer's duties under the terms of the development agreement between them. Here, RE/MAX has been removed from the proposal. Any official action that the petitioner may take relative to the project will directly financially impact the developer and not the real estate company. Additionally, the Ethics Commission has previously opined that a public official is not required to recuse from discussions and decision-making on matters that may financially impact a family member's employer or business associate, unless, of course, there is a corresponding financial nexus between the official action and the family member. Mr. Harvey's spouse is a salaried employee, as I stated, and her salary and bonus are not impacted by any particular sale. Thus, even if RE/MAX had remained on the project or is later added again to the proposal, the petitioner would not be prohibited from performing his duties relative to the project. Accordingly, based on the petitioner's representations, the prior advisory opinions issued, and the relevant provisions of the Code of Ethics, it is the opinion of the staff that Mr. Harvey may resume his duties relative to the project. However, in any of the circumstances change, such as it is reasonably foreseeable that his spouse can be financially impacted by any of his official duties relative to the project, Mr. Harvey is advised to seek further guidance from the commission or recuse. Thank you. I'm happy to answer any questions you may have.
Mr. Herbie, Ms. Goins, do you have anything to add to Attorney Papa's presentation?
I think it covered the case really well. Thank you.
Is there a motion? Do I hear a motion to approve the advisory opinion as drafted by staff in the case of Philip L. Herbie?
I'll move.
I'll second.
That's Ms. Commissioner Susie.
No, Peterson. Peterson.
Oh, I'm sorry. I
Sorry, I heard
misheard
my
it.
voice.
Yeah. Commissioner Peterson moves and Commissioner Rabideau seconds, I believe. Is there any discussion? Hearing none, a roll call vote. Commissioner Susie,
Aye.
Commissioner Centarini,
Aye.
Commissioner Peterson,
Aye.
Commissioner Ritchie,
Aye.
Commissioner Strauss. Aye. Commissioner Rabideau,
Aye.
and the chair votes aye. Thank you, Mr. Herbie. Thanks for coming.
Thank you very much.
The next item on the agenda, or on the sign-in sheet rather, is Patricia Milos and Neil Steinberg.
Morning. Again. So this is at tab C in your binder. This is an advisory opinion for Dr. Patrice Milos. Dr. Milos is a member of the board of directors of the Rhode Island Life Science Hub that I'm going to refer to as the Hub. For the shorts of things. That's actually apparently the official name of it under the statutory scheme also. I don't know if that's what they're going to use, but that's what I'll call it today. The question she's asking is whether she may accept and serve in the position of interim president of the Hub until a permanent president and chief executive officer can be found and confirmed by the Rhode Island Senate. So just to give some of the background here, got a pretty lengthy draft advisory opinion, and my apologies for that. It's the old saying, if I had had more time, I would have written a shorter opinion. And I'm sure that I could have cut this down by a couple of pages if I had given it a little bit. So my apologies there. Nevertheless, here we have it. The facts here are that the Hub is a relatively new quasi-public state agency that was created by the General Assembly in 2023. It really began operating in 2024 after the selection and appointment of Mr. Steinberg as the chairperson of the board of directors of the Hub. The 15-member board was appointed then in January and February, 15-member board of directors, and that is when the petitioner, Dr. Milos, was also appointed. She was appointed to fill one of the 15 slots that is reserved for a member of a life science trade association. So after the board of directors was appointed, at its very first meeting, it set its objectives and started the objectives that are set forth in the statute. And among those, one of the very first things was to hire a full-time president / CEO to run the day-to-day operations of the Hub. This was a position that required a specific skill set, not just managerial skills, but also a firm understanding of life science. And so the board voted to hire a consultant, a search firm, an executive search firm to help them identify appropriate candidates, and they did hire that outside search firm. Some of the other objectives that were established in that very first meeting were to move forward with an RFP to find a firm to help construct an incubator for life science with wet and dry lab space. I will allow these two to tell you what the difference is between wet labs and dry labs. That's not in my wheelhouse, but but to construct an incubator that was one of the objectives. And the other was to hold a summit of stakeholders in life science here in Rhode Island. So with those things, and also to establish a fund to fund life science development in Rhode Island. So back to the search firm, from the representations made by the petitioner, Mr. Steinberg, and then also looking through the minutes of the hub, which are public documents under Open Meetings Act. What we can see is that the firm very quickly, by April, had identified over 200 candidates for this position, began going through them and weeding it down to some semifinalists, and then ultimately identifying 3 finalists for the position that they felt comfortable bringing to the board for consideration. Ultimately, the board would make this decision. So in May, the 3 candidates appeared before the board of directors in executive session for consideration. And from looking at the minutes, what we get is that one of them was deemed to be satisfactory and qualified. And it was reported after that meeting that the board voted to offer the position to that one candidate that had been identified, subject to satisfactory contract negotiations. Now, we don't know what happened after that, except that about a week later, at a special meeting of the board, we can see there is an announcement that the board was going to reopen the search. So we can see that for whatever reason, that candidate fell. So on to round 2, instructing the search firm to begin another round of search for a candidate. The timing issue here, unfortunately, is that this position under the statute also requires Senate confirmation. So the board selects the president/CEO, but it requires confirmation by the Senate. The plan had been, and it was an ambitious plan, was to get this person in place by the end of the 2024 legislative session, which almost always ends in June. And so that they could get the confirmation done and the person in place. As you may or may not know, the Senate has now, I think, recessed is the right word rather than adjourned. They could have adjourned, but I think they generally recess so they can come back into session at any time between now and then. But historically, the House or Senate doesn't come back into session just for a confirmation, especially in a campaign like now when they're all out walking the districts. So the window to get Senate confirmation is over, effective, which means that if a new candidate is named, they won't be named until they won't be able to get confirmed until the earliest would be January, which is the next legislative session. Again, the consultant has informed that it thinks it will get through the second round to come up with some finalists or semifinalists by October or November of 2024. So with that information, and then the hub had already issued its RFP to build the incubator system. And so that's sitting there requiring someone to go through the proposals and to select someone. And that would generally be the president/CEO. Also in May, the hub had a life science summit, the inaugural life science summit at the Rhode Island Convention Center with 500 stakeholders. And the summit is representing that there is this momentum for going forward immediately that will be lost if they're not able to start executing on their plans immediately. With that in mind, the board then voted to hire an interim president that could work on all of these things until the permanent president/CEO is identified, hired, and confirmed. And the board voted to offer that interim position to Dr. Miles, the petitioner. Dr. Milas represents that she left the room and did not participate in the board's vote to offer her that position. And what the offer is a 3-month contract. It could be renewable for an additional period of time, but a 3-month term, paid $25,000 per month, which the petitioner represents, is approximately the pay that the permanent president/CEO will get. The petitioner represents that she, if she's permitted to do this, she has no interest in applying for the permanent position, so it would be a true interim position. And she also represents that if required by the commission to step down off the board while she's serving in that position as interim president, she would do so. So those are the facts and representations that we have. The reason they're here today is because they've become aware that the Code of Ethics contains a provision that generally prohibits this unless the commission gives its permission for it to happen based on a finding that the commission is satisfied that strictly enforcing this provision in the Code of Ethics would result in a substantial hardship to the body, so to the hub, to Rhode Island. The provision that we're talking about is Commission Regulation 1.5.1, which is one of our revolving door provisions. And what it says is that, in a nutshell, an elected or appointed official in the state of Rhode Island, whether state or municipal, is not allowed to seek or accept paid employment or appointment from the body on which they're a member. So here, the petitioner is a member of the hub, a member of the board of directors. The board of directors is responsible for selecting a president and or interim president. Therefore, the rule is that she can't do that. Unless the commission is satisfied that under the particular circumstances as represented and that exist, it would be a substantial hardship to not allow that. And although, this is a provision of the code that many people don't think about, it is one that has come up quite a bit in the history of the Ethics Commission. I've listed several advisory opinions over the years, going back as far as 1995, that I think are similar fact patterns or that show how the commission comes up with its decision-making here. There is no definition of substantial hardship in the code that we can apply. What the commission has determined over the many years is that it will decide every case of whether there's a substantial hardship on a case-by-case basis under the unique circumstances represented. And some of the things that the commission considers when it's looking to see if there's a substantial hardship are questions such as whether and to what extent the position being filled was adequately publicized or advertised. There have been cases where the commission has said no until you go out and do proper public advertising. So that's one issue. Another is whether the position requires very unique and specific skills, or whether, the jack of all trades could just come in and fill that type of position. Also, the question is, are there other qualified candidates available? Even if those candidates aren't perhaps as qualified as the board member, are there other qualified candidates that could fill the position? Also, whether the position has been vacant for a long period of time, whether the appointment or employment is intended to be temporary, a temporary stopgap measure, or whether it's intended to be permanent. And then also whether and to what extent the public official who's being offered the position participated in the decision-making to offer the position to them or to create it. So we look at those factors in this case, and it's the staff's opinion that they're all generally supportive of finding a substantial hardship based on the advisory opinions that we looked at. And I've named a few of them. I note on page 6, the very last advisory opinion that I cite to, which is the oldest, and normally we don't cite advisory opinions this old, 1995, 118. But it's very similar to the facts represented here. If you look at the parenthetical, the commission opined that a member of the Rhode Island Commission on Women could temporarily serve as the commission's interim executive director, where that petitioner was uniquely familiar with the work of the commission and its procedures. The commission had been without a full-time director for over 6 months. She said that she would resign from her position on the commission if she accepted the director position. And that she would only serve as the director temporarily while the commission completed its search for a permanent replacement. And then also that there would be a public hiring process for that person. I think those facts are very similar to what we have here in the instant case. Here, this is a position that requires very unique skills in the life science field. I don't think there's really any dispute that Dr. Milos possesses a very strong life science background and foundation. I summarize her CV. I'm sure she would be willing to share a copy of her full CV with the commission if asked. It appears that there were substantial and reasonable efforts to locate a permanent president and CEO, the hiring of an outside firm to engage in 2 separate rounds of search. There were no other satisfactory or qualified candidates that were identified through this reasonable search. The next round can't be completed until October or November at the earliest. It requires Senate confirmation that can't happen until January. And then the immediate need, and I'll leave that to Dr. Milos and Chair Steinberg to address, but the idea of the RFP that has already gone out, and it's now time to select the firms to help with the incubator and the momentum. So based on all of these factors, based on past advisory opinions, and what I think is an application of that provision of the Code of Ethics, it's the staff's recommendation that there is a substantial hardship to the hub, and therefore that the petitioner should be permitted to accept the position. Happy to answer any questions or just kind of turn things over.
Thank you, Mr. Perrin. Dr. Milos.
I
Chair
have a
Steinberg.
question, if it's okay.
Yeah, we'll get there.
Oh, I had a question for Jason. Okay, sorry.
Dr. Milos, Chair Steinberg, do you have anything to add to what Jason has spoken to?
Perhaps just a few words, if I might, and I think firstly and most importantly, I thank Jason for his excellent work and timely ability to deliver a decision for us on this. The Rhode Island Life Science Hub, as he mentioned, was created by legislation last year. We are operating with an absolute sense of urgency. We have funds for 3 years. And as someone who has lived in Rhode Island since 1989 and have worked in the life science field in Connecticut, Massachusetts, this is truly a unique opportunity to bring this industry to our state. And it is timely and urgent, as Jason said, to do it now. We have the RFP, as he mentioned, out. We'll be moving forward on that. A fund creation, as well as important work and job training, so that people of our state have the opportunity to learn more about the industry and be trained in the industry for jobs in the industry. So everything is timely, and again, a background of about 30 years in life science. And it's an exciting opportunity to do something for our state. And I'm privileged to have the opportunity to be interim director for, what will be 3 to 6 months. Thank you.
Chair Steinberg.
Thank you, just briefly. First of all, thank you for your timely consideration. I'll just underscore 2 things. One is the timing that was referenced. We talk about need, but it really is this opportunity. This is job creation. This is company creation. This is a boost to the economy. And that was the impetus behind doing this. And the opportunities are here now, as Dr. Milos said. We have the opportunity to look at a lab and fund a lab. We did the summit. We will fund companies. We're talking to companies. There's a huge amount of momentum that we want to continue. And the other is Dr. Milos's unique qualifications, not only her CV qualifications. The fact is that as we developed over the last 1.5 years, the case for this life science hub. She was integrally involved. She was chair of the Trade Association, Rhode Island Bio. We were very fortunate to have her on the board from the beginning. If we had to go outside, we'd take another 4 to 6 months just to find an interim while we're spending all our time finding the permanent CEO. We just ran out of time on that. It was not anything more complicated than that. So we're very excited to have Dr. Milos willing to do this when we went to her and also to continue the momentum. So thank you.
Thank you. Do the members of the commission have any questions for Executive Director Gramick, Dr. Milos, or Chair Steinberg?
Thank you. Jason, I think my question is, and I think I know the answer, but is there anything prohibiting the governor from reappointing Dr. Milos to the board of directors after her interim status as CEO? Obviously, she must be a valuable asset to that board, and I think there would be, to fill a 6-month stopgap and lose her as a board of directors. I'm just curious if there's anything.
That's a good question, and I actually talked with Dr. Milos about that yesterday, when we spoke. So I don't believe there is any prohibition. So part of the opinion is that the commission will take her up on her offer to resign from the board while she's serving as interim president. At the conclusion of her employment as interim president, should the governor wish to reappoint her to the board of directors, I don't believe there's anything in the code of ethics and no other law that I'm aware of that would prohibit it.
Thank you.
Commissioner Sarahini?
No, I defer to
Commissioner Susan, sorry.
No, I defer.
Okay. This is more of education of myself. You mentioned on page 5 in the AO that there's a list of circumstances the commission's previously relied upon. And I'm looking at number 6, 1 through 5, totally understand. I just want to know why the question, whether and to what extent the public officials being offered the employment has participated in the hiring process. So why is that a consideration? That's part A, and part B is how involved were you?
Right. So that's a consideration just because you don't want a situation where someone is feathered, right? So has created the need for either the hiring or has participated in putting themselves in that position. So the more that the applicant or the petitioner had, and maybe there's never a perfect situation where they have had absolutely no discussion leading up to that. But the further away that we can place them from that decision making, I think the better, the more supportive it is of the.
So that's why my next question is to you, how involved were you in the process?
So the decision to, I'll let Neil, because I was out of that decision. I left the board. Yeah.
And not when they were talking about you, but in the original, when you had all those applications.
That's different. You're talking about the general hiring.
The hiring, was there a committee,
Well, that
was there a
Yeah,
subcommittee?
that was before we thought we would need an interim, so.
But
yes.
you were involved in
But
As
I
a
that?
was
board- as a
involved
board
in the
member.
subcommittee for the search.
Did you help write the job description that would be advertised?
Yeah.
Okay.
Yes, but that was again when we thought we
Right.
would complete the process.
You're talking about for the
And it was-
permanent.
Yeah, the permanent,
Yes,
yeah.
and it was clear at that time, I said that I wasn't interested in the full-time role because the
And-
board role was so key.
I think that makes a difference.
Yes, I did not apply.
Thank you.
Commissioner Sarahini?
For educational purposes, what is the source of the funding of the hub?
Yes, the $45 million that was appropriated by the Senate is part of the Pandemic Recovery Office funds, the ARPA funds, and it's for a 3-year period.
And is that time limited, that it has to be spent within a certain time?
Yeah, by the end of 2020, calendar year 2026.
All right, so that is another factor in moving forward.
Yes, oh, yes, absolutely. Yeah,
And the other thing, Doctor, will you have any continuing role beyond membership in the trade association?
So I still sit on the board of Rhode Island Bio. I chaired the board of Rhode Island Bio, and I'm officially stepping down from that role.
So, okay, but you will continue as a member.
Yes.
All right, thank you very much for
Yes.
that information.
Any other commissioners have any questions? Do I hear a motion to approve the advisory opinion in case of Dr. Milos?
So moved.
Second.
Motion by Commissioner Sarahini, seconded by Commissioner Lucy. Any discussion? Seeing none, put it to a vote. Commissioner Susan,
Aye.
Commissioner Cederini,
Aye.
Commissioner Peterson,
Aye.
Commissioner Ritchie.
Aye.
Commissioner Strauss.
Aye.
Commissioner Robideau,
Aye.
Rabideau, I wrote it wrong. It's not on my list, but that's it. I wanna get it right.
Believe that.
Completes the vote. Thank you, Dr. Myers.
Thank you very
I'm-
much.
I'm a favor as well.
Thank you.
It's obvious from the beginning. Very nice presentation, by the way.
Great job.
Yes, yes.
Thank you very much.
All right. The next advisory opinion is for Scott Millar, I'm not sure which, Millar.
I think that's there.
That's.
Oh. I saw it.
This advisory opinion draft is in the top B in your binders. Mr. Milano apologizes, he is not able to attend today's meeting, however, he authorized me to move forward and present the draft in his absence. He is aware that that the commission has any questions for him, that you may postpone your decision until a later time when he's able to attend. Mr. Millar is a member of the Exeter Planning Board. He represents the, during a recent review of the Exeter Comprehensive Plan, the planning board determined that the rural residential compound ordinance should be revised. The petitioner volunteered to prepare a draft amendment for review by the planning board members. In Exeter, currently there could only be one dwelling unit per lot, unless the property is subdivided and developed consistent with either the compound ordinance or the conservation development ordinance. The compound ordinance requires for a lot development, a density of one, no more than one dwelling unit per 10 acres of land. The petition explains that, on the other hand, the conservation development ordinance allows a property owner to subdivide and develop his or her land to the maximum number of lots allowed according to a particular residential zone. Mr. Millar explains that in Exeter, there are 3 residential zones. Each of them, all of them are rural, and each of them requiring either 2, 4, or 5 acres of land for the development of a dwelling unit on it. The petitioner has not developed any specific proposal for the planning board, however, he's considering proposing two variants. One proposal to amend would require an increase by 50% of the current lot size necessary for the construction of a home in a particular zone. He gave us an example that if a particular zone requires 4 acres of land for the construction of one dwelling unit, the proposal for the amendment of the compound ordinance would require 6 acres for the construction of a dwelling unit. Another option would be to decrease the number of lots into which a parcel of land can be divided. For example, if a person owns 40 acres of land in a 4-acre zone and is currently allowed to subdivide that land into 10 4-acre lots, the amendment would reduce those numbers to 5. And the person would be allowed to subdivide only into 5 lots. The petitioner and his spouse own and reside in a home on 43 acres of land, located in a zone requiring 4 acres for the construction of a home. Under the current compound ordinance, he represents that he could subdivide his property and construct 3 more homes on his property. He represents that a town resident has raised a question as to whether or not Mr. Millar can participate on in the amendment of, or the drafting of the amendments to the compound ordinance, citing that the petitioner's motive for doing so would be to increase the value of his property. The petitioner explains that an amendment to the compound ordinance on its own will not have a direct financial impact on himself or his property. He points out that the existing conservation development ordinance already allows him to create more lots on his property than the current compound ordinance or any amendments to it. The petitioner and his spouse do not intend to sell or develop their property. And also he explained that they never before filed an application for the development of their property under the compound ordinance. And more notably, the petitioner represented that they have a pending application with the United States Department of Agriculture for the sale of the development rights of their property, so they can preserve the land as is. Here, there is no indication that the participation in the creation of the amendments to the compound ordinance would directly financially impact the petitioner on his property. Thus, based on the above representations, the prior advisory opinions issued, and the relevant provisions of the code, it is the opinion of the staff that the petitioner may continue drafting amendments and participate in the discussions and decision-making relative to the compound ordinance. I'll have to answer any questions that I have.
Since Mr. Millar is not here, do the members of the commission have any questions for Attorney Papa? Seeing none, I have a motion to approve the advisory opinion for Scott Millar.
I'll move.
Second,
I'll second.
motion by Commissioner Peterson, second by Commissioner Rapido. Vote. Commissioner Susie?
Aye.
Commissioner Santorini?
Aye.
Commissioner Peterson?
Aye.
Commissioner Ritchie?
Aye.
Commissioner Strauss?
Aye.
Commissioner Rabideau?
Aye.
The chair votes aye.
Thank you.
Thank you. The next item on the agenda is a motion to go into executive session. To wit, a motion to approve minutes of the executive session held on June 4th, 2024 pursuant to RI Gen Law, section 42-46-5, paren A, paren 1, comma, paren 2, and paren 4, the In re Scott Millar, complaint number 2024-8 pursuant to RI Gen Law, section 42-46-5, paren A, paren 2, and paren 4. And in the matter of Wayne Salisbury, complaint number 2024-9 pursuant to RI Gen Law, section 42-46-5A2 and paren 2 and paren 4, and then a motion to return to open session. May I hear a motion to go into executive session? Commissioner Susie, is there a second?
Second.
Second by Commissioner Santorini. Commissioner Susie?
Aye.
Roll call vote.
Sorry, aye.
Commissioner Santorini?
Aye.
Commissioner Peterson?
Aye.
Commissioner Ritchie? Commissioner Strauss?
Aye.
Commissioner Rabideau?
Aye.
And the chair votes aye. Going to executive session.
So the meeting will close during executive session, and once it's over and open session begins, the same meeting will reopen.